Today we're going to be discussing two very important parts of the patent process: who can apply for a patent and who can own a patent. For a quick refresher, what is a patent? According to IP Australia, a patent is a right that is granted for any device, substance, or method process that is new, inventive, and useful. A patent is a legally enforceable right to commercially exploit the invention for the life of the patent. Section 18 of the Commonwealth Patents Act of 1990 sets out two types of patents. The first type of patent is a standard patent. A standard patent must be novel and must involve an inventive step. This means that the invention is not an obvious thing for someone that is knowledgeable and experienced in the field of the invention. Essentially, the invention must differ from any existing technology. It must be a brand new invention. This second type of patent is an innovative patent. These require a lesser degree of inventiveness than standard patents. They must be novel and must involve an innovative step. An innovative patent builds on an already existing invention, but must provide a substantial contribution to it. For example, inventing a laptop, which has the basic background of a desktop computer. So who exactly can apply for a patent? Luckily, the Patents Act is fairly straightforward in regards to this question. Section 29 of the Act provides, a person may apply for a patent for an invention by filing, in accordance with the regulations, a patent request and such other documents as are prescribed. Section 15 of the Act provides that a person who can be granted a patent must be either the inventor, someone who is entitled to have the patent assigned to them, someone who has derived title to the invention from the inventor, or the legal representative of any of the aforementioned people should they become deceased. So who can own a patent? As previously mentioned, Section 15 of the Act states that the inventor can apply for a patent, but a person can also acquire rights to an invention. Rights can be acquired by purchasing the right or in the course of employment. Employers have a right to claim ownership of employee inventions when there is an express term in the employment contract. However, this term should not be so broad that it results in a restraint of trade. Employers also have a right to claim ownership of employee inventions through implied terms. This means that where employees are engaged to use their inventiveness in the course of their job, they will be considered to be doing work they are paid to do. In the case of University of Western Australia against Gray, the court found that the ownership of an invention is implied only where the employee owes the employer a duty to invent. There can also be joint inventors and owners of a patent. Joint inventors will take ownership of a patent as tenants in common. Each of these inventors is entitled to work the invention as they wish. However, all joint inventors must consent to the granting of a license or assignment of an interest over the invention. In summary, Australian patent legislation sets out two forms of patents that can be applied for: a standard patent for an entirely new invention, or an innovative patent for building upon an already existing invention by way of substantial contribution. Section 15 of the Commonwealth Patents Act sets out those that are entitled to be granted a patent. If you create an invention with another person or persons, you may also apply for a patent as joint owners. And remember, if you create an invention in the course of your employment, your employer may be entitled to ownership of the invention, either explicitly or implicitly.